Si un abogado hoy desea realmente hacer investigación o analizar un fenómeno jurídico serio, no puede hacerlo sin pasar por el campo de la sociología.
La capacidad de reflexionar interdisciplinariamente, la capacidad de entender los fenómenos sociales y de conocer lo que a uno le inquieta de la sociedad desde muy diferentes aristas.
Mejores herramientas para contribuir al progreso cotidiano del derecho y la justicia, que al fin y al cabo es el eje de la misión del jurista verdadero.
Pasamos a la siguiente conferencia, que se llama Experiencia y análisis relacionados con los mecanismos de reclamación proporcionados por la Mesa Redonda sobre aceite de palma sostenible en Indonesia, a cargo del profesor Yance Arizona. El doctor Yance está haciendo un gran esfuerzo porque él también viene de muy lejos, está en Indonesia y son 12 horas de diferencia con él. Yance Arizona es doctor en la Escuela de Derecho de la Universidad de Leiden, en Países Bajos. Maestría en Sociología Jurídica en el Instituto Internacional de Sociología Jurídica de Oñati, en País Vasco. Es profesor de la Facultad de Derecho de la Universidad Gadjah Mada, en Indonesia. Ha publicado varios libros y artículos sobre derecho de tierras y sobre comunidades indígenas en Indonesia. Muchas gracias, profesor Arizona, y lo escuchamos.
My name is Yance Arizona. I graduated from Oñati International Institute for Sociology of Law in Spain in 2016. I found that there are many other Oñati's alumni in this conference as well. I saw that in the list that there was Vincenzo Ferrari for speakers, yesterday's speakers, and also Gloria, and of course there are also Fabio, Pedro, and also Camilo Umanya, who will participate in this today's conference. I'm graduated for my PhD from Van Vollenhoven Institute for Law, Government Society from Leiden Law School in Netherlands. And currently I'm a lecturer at the Faculty of Law, Universitas Gadjah Mada in Yogyakarta, Indonesia. And also a practicing lawyer as a senior partner of Villa Law Firm in Indonesia. I have several experiences for being a consultant for UNDP, RSPO, Roundtable Sustainable Palm Oil, which is that I will discuss today, and international level organization, and also any other international and national agencies. And for this occasion, I would like to discuss about the topic on access to justice. Broadly speaking, that access to justice is a process where individuals or groups try to obtain justice provided by state agencies. Many literatures on access to justice discuss how people can access the court and other state institutions to obtain remedies for violation of their rights. OECD, one of the international institutions, define access to justice as the ability of individuals and businesses to seek and obtain a just resolution of legal problem through wide range of legal and justice services. And also, so I found that many studies about access to justice focus on the relationship between the state and society, and a very few studies discuss about access to justice by invoking market institution. And at this moment, I would like to discuss the compliance system, the grievance system provided by a certification agency called Roundtable on Sustainable Palm Oil, or RSPO. This is an example on how a multi-stakeholder organization, a transnational organization basically, for a specific product, try to provide a grievance system for people who have complained about the accountability of particular business. So in Indonesia, the rapid expansion, the rapid growth of palm oil is very expansive. Palm oil is a vegetable extracted from the palm tree's fruits. This crude palm oil is used for various products, such as food, cosmetic, biofuels. In Indonesia, palm oil was first brought by the Dutch colonial government during the colonial period, especially in 1848, when the Dutch brought 4 palm oil seeds from Africa to Bogor Botanical Garden in Indonesia. And currently, after 175 years, more than 14 million hectares of Indonesian land are covered by palm oil trees, making this palm oil is very big business in Indonesia. So to compare that, 14 million hectare is around 20% of non-forested area in Indonesia. So the expansion of palm oil in Indonesia led to several social and environmental problems. For the people and also for the environment. The first problem related to the land conflict between palm oil companies and local and also indigenous communities, because most of the palm oil operates with the land of indigenous and local communities without their consent. So the palm oil obtain permit and also land use right from the government without prior consultation to indigenous communities. So it involves land grabbing and appropriation of land of indigenous people from their living space. In 2022, an NGO called Consortium for Agrarian Reform found that the plantation sector has become the highest cause of land conflict in Indonesia. This NGO reported 99 land conflict in the plantation sector with an area of more than 377 hectares and provide impact to more than 141 families. Another problem is related to the environment. The establishment of huge monoculture palm oil estate required land clearing. Many tropical forest areas have been converted into palm oil plantation. This is also the main cause of the lost biodiversity. For several years, Indonesia has had problem with the forest fire as well, because most of forest fire occurred in Indonesia for preparing land for palm oil plantation. And then this also led a problem with Indonesia, between Indonesia and Malaysia and Singapore, because of the smoke from Indonesia goes to Singapore and also to Malaysia. So consequently, this deforestation and land degradation contribute to the greenhouse gas emission from Indonesia. So people expected that all problems related to palm oil expansion can be solved through the legal system. However, there are a lot of problems with the current legal framework related to the protection of indigenous and local communities' land rights in Indonesia. I don't know whether it is also a problem in Colombia. Some provision in the Constitution really protect local and indigenous land rights, but the formulation of that provision in the Constitution is very problematic, because the protection of indigenous land rights only can be granted after the indigenous community obtain formal recognition from the government, which is the process of obtaining legal recognition is very complicated. Another problem with the legal framework is that legislation created by the government and the parliament facilitates large-scale land plantation to generate state income and also become a subject for an illicit benefit for elite in form of corruption. This government expected to level up people's position and deal with the corporations, which worsened the situation. As a result, many land conflicts remain unresolved due to imbalanced position between local indigenous communities and palm oil growers. It shows no effective mechanism for resolving conflict, especially provided by the court and the state institution. So another alternative to solve land problem for local and indigenous peoples is to file a complaint to multi-stakeholder organizations, such as the RSPO. RSPO, Roundtable on Sustainable Palm Oil, was established in 2004 as a multi-stakeholder institution consisting of palm oil growers, palm oil processors and traders, social development NGOs, environmental NGOs, and smallholder palm oil farmers. So certificate areas under the RSPO cover more than 4.8 million hectares, which with more than 3,000 certified companies from Indonesia, Malaysia, Liberia, and also Colombia, Papua New Guinea, and other countries. So RSPO commit for supporting sustainable palm oil by promoting three main pillars, which is prosperity, people, and planet. Furthermore, RSPO created principles and criteria as the guiding regulation for the certification process, and also a standard for settling compliance with the RSPO members. There are 7 main principles. 2 of them are principle 2, operate legally and respect rights, and also principle 4, respect community and human rights and deliver benefits. In 2009, the RSPO adopt complaint system that made any people or NGO concerned with people and environmental and the environment can file a grievance to the RSPO. RSPO created grievance unit to handle any complaint to the RSPO member for the operation. For more complex cases, the RSPO can settle a complaint panel to decide a case to ensure the accountability of the members. One of the crucial criteria in the RSPO PNC, principle and criteria, is the criteria number 4. The use of the land for oil palm does not diminish the legal, customary, or users' rights of the other users without their free, prior, and informed consent. So this criteria is basically not only rely on the legal, state national legal system, but also to the customary law as well. So the land rights rely under the customary law. And so this criteria is very important for the Indonesian context because many local and indigenous communities have lacked legal protection from the state. Therefore, they can use as RSPO criteria as an alternative of legal basis to level up their position to speak with the companies about actual land conflict. The national law in Indonesia does not adopt free, prior, and informed consent. Consequently, many companies, especially during the Soeharto authoritarian regime, 1966 to 1998, used in this indigenous communities' land without their consent. So in short, that the RSPO complaint system provide an alternative mechanism to access to justice. So in 2019, I did a study for RSPO about the increase of complaint from Indonesia to the RSPO complaint system. So at the time, they asked me to do a study, and RSPO asked me to do a study because there are many complaints came from Indonesia to the RSPO compared to other countries. So in that year, 65% of complaints from to RSPO came from Indonesia. And in 2019, I found 84 cases from Indonesia, and 66 cases were analyzed for that study. Most of the complainants to the RSPO complaint system was NGOs, basically. For some cases, NGO also representing local and indigenous community and file a case to the RSPO complaint system. So the nature of conflict was diverse. Most of the complaint related to the land rights and the free, prior, informed consent, as you can see in the presentation. Follow up with the environmental and orangutan protection cases. Some cases also related to land use, labor rights, partnership schemes, and transparency of companies. So it shows that the RSPO has become an alternative for resolving land conflict, especially related to free, prior, and informed consent for the use of the indigenous or local communities' land for the palm oil plantation. I also found that there were 50 one complaint has been closed from 60 cases in 2019, with most of them being the palm oil company that made some adjustment to fulfill the RSPO standard or made a bilateral agreement with the complainant and referred to dispute settlement facility provided by RSPOs to solve the problem. But there were also cases has to stop because lack of evidence and participation from the complainant, and also there was also termination of membership of the RSPO members as well. So it shows that the complaint system facilitated conflict resolution and hold palm oil companies accountable. So from that cases, and then I try to identify what is the enabling factors for the increase of complaint from Indonesia to the RSPO complaint system. So I found that external and internal factor to the increase of complaint. For the external factors, so I found that the palm oil expansion remained massive in Indonesia. It provides potential social and environmental problem under tenure uncertainty at the ground level. So the potential of cases is huge. So that's why the case is also increased. And many land conflicts remain unresolved due to the imbalance between local and indigenous communities with the palm oil growers. Incompatibility between the RSPO standard with the national law as well. In this case, I found that even the RSPO standard is better than the national legal framework in terms of the protection of indigenous and local communities' land rights. And also the active role of NGO using the strategy from and also within and outside of the RSPO, because there are also NGO member of the RSPO, but there is also NGOs that are not member, but they are really active from outside to file a complaint to the RSPO. And there is also a context of democracy and openness in Indonesia, especially after the authoritarian regime in 1998. And so it's provide a better environment for people and also NGOs to improve their awareness and channel their grievances to any available forum for remedy. One of them, of course, using the RSPO mechanism. People increasingly, this is also very interesting because people increasingly accept palm oil operation in the region, yeah. But they would like to get benefit from the palm oil plantation. And the last external factor is the limited effective mechanism for resolving the conflict, especially provided by the court. So using the court is not the primary strategy for people who have land conflict in Indonesia. But there is also internal factors that to the increase of complaint. The first is that the RSPO complaint system is accessible and free, and complainant can also request to protect their identities in the complaint process. Another factor is the RSPO has a legitimation to compel company to respond to the complainant. Also, in many cases that the local community or indigenous community feel their complaint to the RSPO in order to have a forum to speak together with the top leader of the company. Yeah? So in that objective, the RSPO can also help to leveling up the local community's position to can speak equally to the representation for the company. And the complaint panel decision is deemed to be a precedent by repeat players and able to set a framework to resolve a similar cases in different communities. So there are many NGOs that I mentioned before that also really active using the RSPO. So once they get successful of using the RSPO, and then they come again to use the RSPO again by using different cases to help people who have land conflict with the company. So another factor is that the RSPO focuses on the sustainability and remedy rather than penalty against the member who do not meet their RSPO standard. So there is no penalty, but the main objective is to how to make the company can adjust the standard and also to provide them complainant. So, and then also I found that the RSPO also completes the week of national law to protect citizens, especially in guaranteeing local indigenous people's land rights, free and prior informed consent, environmental protection through the high conservation value. And the last is that the retroactive principles of the RSPO standard makes invisible cases in the past become visible in the complaint system. So, you know that the RSPO is established in 2004, but many plantation, palm oil plantation has obtained permit more than 20 or 30 years before, and then people can also file the case or the complaint to the process as well. And I arrived to the final slide of my presentation about the lesson learned from this case. So it's basically one case study, different with Gloria, but I hope that can be we can discuss one topic for this case. So I found that some lesson learned from this case, that in situation where the state legal framework is not strong enough to protect people's rights and the court are corrupt, non-judicial and non-state settlement mechanism can be an alternative. So RSPO is only one example of that. Of course, there are many others, like in forestry sector, there is also Forest Stewardship Council. And I found that there are many other certification body for different products. And the complaint resolution model through the RSPO is just one of model in this settlement, as I mentioned before. The RSPO model encourages companies to be more accountable in carrying out their operation while still paying attention to the community and environmental safety. So it is not only about how to make the company accountable, but in another side is also a way of for local and indigenous community to obtain remedy for the violation of their rights. And such a settlement model like the RSPO model is in line with the UN guiding principle on business and human rights. And the last point, that this model of settlement opened up a new interesting subject on the global legal pluralism to understand how non-state conflict resolution emerged from not from society but from market mechanisms. So and I think that it is a new topic that also important in sociology of law, which is not only to see the relation between state and society, but also to think about the market itself, also trying to change, to adapt to the demand of the local communities, indigenous communities, and also to the demand of the environmental activists. So I hope that it is can generate a discussion for this session. I think I open up opportunity for question or clarification or suggestion from or comment from all participants.
¿Hay preguntas dentro del público?
Muchas gracias por su exposición. Quisiera saber de qué manera todas esas denuncias que han sido llevadas a las cortes, aunque usted menciona casos de corrupción que seguramente no prosperará en el sentido de alguna indemnización, de qué manera, digamos, dentro de términos generales, de esas denuncias presentadas, ¿tienen alguna compensación las personas que son afectadas? Por ejemplo, en Malasia, con la época en Indonesia de quemas, por la necesidad, digamos, de la renovación de las plantas, de las palmas, esa contaminación que se genera, no solamente a nivel local, sino en otros países. La pregunta es, ¿de qué manera se compensa y en qué cantidad, digamos en términos globales, viene a haber esa remuneración para las comunidades afectadas?
Yes. The first is about the court. So I don't know, in Indonesia, using the court is not the primary strategy for people who have land conflict, whether they base their claim for indigenous or non-indigenous land rights. Because using the court that first that because they have lack of the legal basis for the land or ownership. So if they go to the court, usually the court will be very formalistic to ensure that if they have document for the land rights. Most of the indigenous communities, they don't have the land certificate for the communal land rights because the government never provide proper procedure for recording all of the indigenous land rights in Indonesia. And another is that by using the court, meaning that they need to follow a very complicated and multi-layered process as well, because after let's say if you win in the district court, you need to go to the appeal court, and then after that you need to go to the Supreme Court. So the process can take more than 5 years. And another that when using the court, usually the company only decide to ask their lawyers to face the people to people who fill the case. But in the RSPO system, that it is become the concern, really become the concern of the company top leaders, because if the certificate from the RSPO is terminated, it can provide real impact to their product, to their main business. And for the case related to the compensation, there are some cases from my study that I found that where people trying to file a grievance to the RSPO, and then it can be substantiated by the court, by the complaint panel, and then they can get compensation. But there is also another cases related to the use of indigenous land in one area in Sumatra, where the final process that the company then recognized the use of customary land of the indigenous community in Sumatra, and but then the community itself also willing to collaborate with the company. So that's what I found. That's what I say before, that in some case, in some location, that local communities, they are also welcome with palm oil operation. The only thing that they really would like to get benefit from the business. So they don't would like to have their land, lost their land. So they really would like to get benefit. So they welcome the mining, the palm oil company, and then they create the agreement, mutual agreement. So before that, the land is the company get the land from the government without consultation or consent from the community. But then after they fill the case to the RSPO, and then the company agree, and also recognize the customary land rights of the community, and they make agreement. So after the land use right by the company end, so the company will give the land back to the community. So in that sense, I found that there is also some concrete solution for individual or collective or customary claim filled by communities to the RSPO. And another is related to the forest fire, for instance, or environmental destruction. Yeah? So, because all of many company also in the RSPO, they obtain their permit during the Suharto period. At the time, regulation about the environment is not as strong as right now in Indonesia, but they do some adjustment to follow the regulation, for instance, by creating the particular area within their concession as the high conservation value area. So they are not creating all of plantation from all of their concession, but also provide some area as a research area for to support the environment as well. And yeah, of course that right now, if they would like to expand their area, so they need to ensure that they are not doing deforestation to establish a new area for plantation. But in most cases that the member of the RSPO, they already have plantation already, yeah, and then they get certification. So it's meaning that they are not expanding their area. So in that sense, that the possibility for them to involve in their deforestation also decrease. So that is my response to that question.